One of the fundamental principles under the Outer Space Treaty is that outer space shall not be subject to appropriation. That's generally been interpreted to mean that states, the domestic law of states doesn't apply in outer space. Their domestic law might apply within their own spacecraft for other reasons, but Australian law, for example, doesn't apply in outer space, Australian privacy law, for example. As a result, there aren't really any recognised property rights in outer space. One would have thought, with the increasing number of diverse commercial activities in space, that private enterprise, as they develop their activities, will want some form of legal certainty, they'll want forms of legal protection, and one of the challenges is to try to provide that, but somehow keep within the anti-colonialism viewpoints of the Outer Space Treaty. So we might need to develop some form of quasi-property rights. Indeed, it's sort of already happening by stealth. We have an orbit in outer space called the geostationary orbit, which is a very valuable orbit, about 36,000 kilometres above the Earth. That's where a lot of our telecommunication satellites are. It's a valuable orbit because satellites in that orbit remain stationary over the Earth, which obviously makes it a lot easier and cheaper in terms of receiving signals, and their footprint remains stable. Now, those orbits are valuable, and there's only a limited number of orbits that can be utilised. And so a system has been developed whereby a United Nations agency now allots those orbits to different countries. So in a sense, we're beginning, even despite the Outer Space Treaty, we're beginning to find that we need to have forms of some sort of propriety rights to allow activities to happen. That probably needs to be expanded upon, but it's a dangerous and it's a bit of a slippery slope. Once you start allowing property rights, then in a sense you change the very nature of our regulation. As I said, our regulation is no appropriation. We view outer space as this area that belongs to all of us, a res communis, a common area, a common heritage. Once you start allocating property rights in a formal sense, you challenge that. And they're difficult issues that we need to address.